SJC-11808, Commonwealth versus Sullivan. Thank you.
Ms. O'Brien, good morning.
Good morning, Your Honors. Leslie O'Brien for Mr. Sullivan. May it please the court. Just very briefly on the facts of the case, I realize the court has the briefs. As the court knows, this case involves the robbery of a 62-year-old man by the name of Mr. Vieira in his home in West Medford. The intended victim, Mr. Vieira, admitted at trial that he was a drug dealer. At the time of the intrusion into his home in this case, his son happened to be staying in the home, and there was a fight that occurred. Both father and son engaged in the fight, and it culminated in the shooting, the fatal shooting of the son, and the shooting of the father as well. Now, I'd like to begin with the argument that's raised in Mr. Sullivan's supplemental brief regarding the motion for a new trial. About 2 years after his trial, we received some discovery from the prosecutors. And the discovery was essentially that the lead criminalist in the case, who had responded to the scene, had failed some competency testing in the area of trace evidence recovery. He testified at trial, the criminalist testified at trial, that he was in charge at the scene, that his function was to gather the biological evidence in the case.
Can you answer for me, what was his role as far as looking, because clearly they missed the holster, well, everybody did.
Yes.
What was this criminalist's role in the search, or did the state police search for the items and he would later document or recover them? I'm confused as to who has eyes on the apartment, who's looking for what.
Well, he specified, Mr. Kester, the criminalist, specified that his role as the supervisor there at the scene was in regard to biological evidence, such as blood, hair, fibers. He gave some examples like that. But it does seem as if it certainly wasn't said that wouldn't have been part of his responsibility as well, to look for things that might contain that type of...
But the state police, the criminalists, the state police crime scene service people, they're the ones that are looking. They're the ones that missed the holster and the other article, right, of jewelry, I think it was?
I wouldn't say that's exactly correct. I think that the crime scene services people were also there to look for things that might contain biological evidence, that was part of their duty as well, to examine the scene.
So let us assume that we accept your argument that if the jury had known all that was later revealed, that they would have had a very, very low estimation of Mr. Kester's proficiency and competence. Why would that have affected their evaluation of the weight of the evidence?
It would have affected their evaluation of the evidence because what would have occurred if the evidence had been presented, if the evidence had been provided as it should have been, was that there would have been a Bowden defense available to the defendant, a far more powerful Bowden defense than was available because this evidence was withheld. So what I'm saying is the jurors would have learned that not only that the person who was in charge of the scene had failed this testing, but that he was generally incompetent, that he had a pattern of making errors.
He gets the article of clothing, he recognizes it as blood, he gets the mallet, he then gives it to the DNA people and they do their thing.
Yes, but he handled, according to his testimony, he handled almost all of the evidence in this case. He handled the various items there. And what I'm really getting at, to be clear, is that this would have been an entirely different case. I'd ask the court, for example, to imagine the type of cross-examination that would have been done of Mr. Kester. Mr. Kester surely would have been asked, isn't it true that trace evidence would be critical in a case where there was close combat between a perpetrator and a victim? And isn't it true that trace evidence includes such things as hair and fibers? And isn't it true that hairs can be studied analyzed for DNA evidence and can even result in a positive identification of a perpetrator? And isn't it true that you, 9 months after your examination of this scene, were given a competency examination and trace evidence examination, and you missed a hair in that test, and you were even given a second opportunity to examine that evidence, and you missed that hair the second time you were given an opportunity to take that test? So that...
And therefore, in your closing argument to the jury, because Mr. Koster was incompetent, therefore members of the jury?
Well, it's a Bowden-type evidence. If there had been a competent examination, hair might have been found, for example, on the clothing of the victim, which was introduced into evidence. There was no testimony that was ever examined.
So are you saying it's too late at this point to do any of that kind of testing?
It may be. It's obviously a very delicate type of evidence, trace evidence.
But we know
I'm not saying it's impossible.
But we know 2 people entered the room, because someone's still alive, right? We know 2 people entered the room. They claim that one of them is your client. Your client says that he was there himself. He admits he was in there, and then some guy walked in after him and committed these crimes. So we know that unknown people were there. So what you're saying is that we could have had unknown hairs that they missed?
Yes.
But we have mystery man.
Yes, we know there's a mystery man. The mystery man, the argument would be to the jury,
This is
would
further
be asking the
evidence?
jury to consider that this other person could have been identified if there had been a careful examination of the scene, and that could have been exculpatory. It's the nature of a Bowden defense that it points out to the jury that things could have been done that were not done in this case, that the case was handled improperly, it was handled incompetently, so you haven't heard all of the evidence. That's the nature of a Bowden defense. That was what the defendant was deprived of here. And he should have been allowed to show, now the judge's response to this was that, well, you're saying that there was prior misconduct, but that wasn't the argument at all. And that would be an absurd argument to say, well, we should have been able to show that there was prior misconduct by this individual. What the jury should have heard was that the lead criminalist in this case was sloppy, incompetent, and if the material that's now been provided that at this late date by the prosecutors is fairly examined, that's inescapable.
Does this have anything to do with the holster that was not found for 3 days under the sofa?
Well, that's part of the argument. Now, granted, defense counsel did have the argument that there was sloppiness here. The holster wasn't found. The jewelry wasn't found.
But was he in charge of that, or was somebody else in charge of that?
That was really not clear. I mean, certainly these are the types of things he should have been looking for, because they were looking for things that might have biological evidence. So there was the potential there for a Bowden argument. It wasn't really made, if you look at the case. There was sort of a glancing blow in that direction, but it wasn't really fleshed out. It wasn't the type of powerful thing that it would have been if the defendant had this evidence of the incompetence of this individual who was the supervising criminalist at the scene. And lest the court think I am making a mountain of a molehill here, I'd ask the court's attention to the supplemental appendix, to page 26 of my supplemental appendix with the supplemental brief. And that's a memorandum by Mr. Kester's supervisor. And she talks about examination of 150, originally 177 cases that Mr. Kester looked at. In 150 of those, no trace evidence was recorded. So they looked at 2 of those 150 at random, and in one of them found abundant trace evidence that had not been recorded.
Can I ask you, did I see something here that they did retesting of the stuff here in this case?
There was no, the prosecutor indicates that the case was reviewed. I wasn't able to find any indication of a thorough review of this case. It's just not there, or I wasn't able to find it. There's no indication that there was indications that Mr. Kester's casework was being looked at carefully, which isn't terribly surprising given the supervisor's conclusion on that same page regarding his failure. The failure to collect potentially probative trace evidence questions the quality of Mr. Kester's work and the potential for it being a systemic issue. So if there's a mountain here, it's not of my making. It's a mountain of Mr. Kester's making.
So how would Mr. Kester's purported incompetence in any way affect the DNA match with the pipe and the mallet, which Mr. Vieira said his son was hitting the tall guy over the head with before he got shot?
It wouldn't have a lot of relevance in this case because all of that testimony was consistent with what the defendant said when he testified.
But the tall guy that got hit with the mallet was the shooter.
Well, there was testimony to indicate that was the shooter in the case.
Isn't that your problem?
The jurors would have had reasonable doubt. They would have had more reason to have reasonable doubt in this case if they had been provided with all the evidence. I don't see how there can really be any question that this should have been turned over. Should it be said, oh, this was fine, this was okay for the lab, which it can even be inferred that they seem to be covering up for him at points. Is there really any excuse for them not turning over this evidence, for the defendant not having the benefit of being able to question whether the scene was competently examined, whether the mystery person that he described in his testimony could have been identified, could have been found to be somebody completely unconnected with him? I just don't see how this can be excused.
Well, I mean, the issue is not whether, well, I mean, we'll see, we'll hear what Ms. Langsam said, but I gather that there's no claim that the ADA knew about.
No, I'm certainly not claiming that, and I have no reason to believe that that's the case, not at all.
You're saying there was the obligation of the lab when they put Kester forward as a witness to say, you should know this, you, the DA, should know this about Mr. Kester.
The lab and Mr. Kester. And I should point out, I know—
Judge Liebensberger focused on the second 2 prongs of Brady, right? Materiality and prejudice.
Yes, he basically said that the defense is trying to offer evidence of prior misconduct, which it wasn't at all. He could just completely misconstrued the argument. He found that it wasn't even exculpatory and not material and not relevant. And you know, I'd suggest that this is something that really cannot and should not be swept under the rug. It shouldn't be something that the state lab should think is fine to do. It would be one thing if we were talking about a mistake or even two mistakes by this man. But if you look over what's now been provided by the prosecutors, this man was a terrible criminalist. I don't know whether it was incompetence or sloppiness or both, but he's a nightmare. He was a nightmare.
If we can turn to the CODIS hit, again, let's assume that you are right, that the jury should not have heard that it was a hit or that it was a match.
Yes.
But what is the consequence of that where they went on to get a buccal swab from the defendant and then did bring a DNA expert in to say, I have examined the buccal swab from the defendant, and here is my analysis of the DNA, and it was cross-examined as to that?
Well, the consequence is, I'd suggest to the court that there was a reason that the prosecutors were bound and determined to get this evidence in, that the defendant's profile was contained in CODIS. No one was challenging how the police came to look at Gerald Sullivan. If a police officer had testified, we gathered DNA buccal swabs from various people, including Sullivan, and his DNA turned out to be a match to items found at the scene. There was no problem there. Yet the Commonwealth insisted on having that evidence, and I suggest that there's a reason for that they were well aware that makes the defendant look bad, that it's a little something extra to make him look bad. And
Let's assume that I take your point that it should not have come in.
yes,
But there was a DNA expert who did testify and was cross-examined, so why does it matter so much that they had the earlier CODIS hit when they were not relying upon that alone to prove the DNA match?
because as I say, it's just an extra little something to whose purpose is nothing more than to create that additional character evidence. I don't know what more I can really say about that, Your Honor. If I may, I would like to turn to the argument regarding the felony murder, which was based on 265-18C, which requires proof beyond a reasonable doubt that the defendant was armed when he entered the home. The sum total of that evidence offered by the Commonwealth is that Mr. Vieira stated that he did not have a gun and never saw his son with a gun, and then there was a cousin who came in to clean up and said, my family doesn't mess around with guns.
In a light most favorable to the Commonwealth, which we have to look at it, if the evidence is that two people enter, one shorter than the other, the tall guy tussles with the victim, the tall guy shoots the victim, the tall guy got hit on the head with a mallet, and the mallet DNA is your client, doesn't that show that your client was armed, and isn't that sufficient?
It would be evidence, if believed, that he was armed that he was at least armed after he entered the, and part of what I'm pointing out here and reference.
You're picking and choosing the evidence, so if it's in a light most favorable to the Commonwealth, and we credit what the victims, Mr. Vieira said and his family said, that we didn't have guns, isn't that it?
Well, as has been pointed out to me by prosecutors in different arguments before this court, when the court looks at the evidence in the light most favorable to the Commonwealth, it looks at all of the evidence. And all of the evidence showed that the two intruders came in, that they initially jumped the 62-year-old man, inferably believing that they were going to have an easy time just containing the 62-year-old man, that they were unexpectedly confronted by the 62-year-old son, and this became a completely different matter. The court would also consider, I assume, the fact that the holster was found next to the pipe and the mallet, next to the body of the victim. All of those three things were together. So what you have left to counter that, in the light most favorable to the Commonwealth, supposedly beyond a reasonable doubt, is again this testimony, well, I didn't see my son with a gun, and the testimony of the cousin, my family doesn't mess around with guns. I'm simply suggesting that can't rise to the level of proof beyond a reasonable doubt.
Okay, thank you.
Thank you, Your Honors.
Good morning, may it please the court. Good morning, may it please the court. My name is Jessica Langsam. I'm an assistant district attorney for Middlesex, appearing on behalf of the Commonwealth. I was the second seat in this case. With me today is Elizabeth Dunnigan, who is the lead trial prosecutor. If I could just address the issue that counsel just left with. There was more evidence than the evidence that the court just mentioned, that counsel just mentioned. Mr. Vieira testified not only that he didn't have a gun, that he never saw his son with a gun, he also testified that while he was grappling with the shorter, stockier man, he didn't feel a gun. And as Justice Gaziano mentioned, it was the taller man who was grappling with the victim, John Hatch, who was shot and killed, who shot and killed John Hatch, then, as Mr. Vieira said, looked at him, pointed the gun at him, and shot him in the right temple. And obviously, Mr. Vieira survived. So there was substantial evidence from which the jury could infer that at the time of entry into that apartment, the defendant was armed. Nothing can be taken from the fact that the pipe and the mallet, both of which a single source DNA profile was extracted, which matched the defendant's DNA, and the holster were found in the same area. This was a very small apartment, and the front door, when these two individuals burst into the apartment, there was a couch there. There was kind of a small living room that led to another room where there was a bar, and then there was the back bedroom, where Mr. Vieira's wife, Darlene, heard the shouting and heard the commotion, heard the shots, called 911, and was on the phone with 911 when one of the intruders, the Commonwealth contended it was the defendant, stepped into that back bedroom. She heard another voice say, "They're dead, let's go," and then that person left the room.
Now, the size of the apartment invites the question of how can you miss the holster, the mask,
Yes, Your Honor.
the pendant, which I guess was in the hallway.
Yes, Your Honor. Actually, I believe the pendant was on the doormat. This was a very valuable, I think it was approximately $9,000 that Mr. Vieira, who was a jeweler, testified that he wore. It had diamonds and rubies. It was a cold night, and the crime occurred at approximately 10:30 p.m. on Friday, February 18th of 2011. This was an apartment, it was a crowded apartment. It was a cramped apartment. If the court has had the opportunity to look at any of the photographs taken of the interior of the apartment, the front apartment had a couch. There were a lot of items in this apartment, including items that had been left on the coffee table. When the first responders came, the police arrived. Mr. Vieira actually answered the door. The coffee table was moved, and there might have been items that had previously been visible that could have been pushed. That's not clear from the evidence. So when Mr. Hendricks found the holster, which he saw underneath the couch, the other evidence, which was mentioned by the court, was that Mr. Hendricks testified holster didn't belong to him or to anyone in his family, and no one in his family played with guns. So that evidence obviously went to the possession of the gun in the commission of the armed home invasion, which was the predicate for the felony murder.
Is it your view that you can get in the CODIS hit the way you got it in?
It is, Your Honor, and I think that this
How?
court...
Under Tassone?
Well, Your Honor, under Commonwealth versus Guy, which is cited favorably in Commonwealth versus Bazanowicz, that's it. First of all, for clarity purposes, CODIS was never mentioned. And the Commonwealth's motion in limine...
Well, how did the evidence come in? Okay, CODIS wasn't mentioned. You did a search of a national database.
Yes, Your Honor.
And it turned out that his DNA was a match with the DNA from the mallet and the
mallet
pipe.
and the pipe and the major profile from the black and gray hat, which was the
And
defendant's
if you
hat.
had, is it your view that if you had not offered the DNA expert who you ultimately did, that evidence would suffice to allow you to argue that there was a DNA match?
No, Your Honor. It certainly wouldn't have been enough to suffice if we had not had the individual from the Mass State Police DNA unit who tested the defendant's buccal swab, which was then compared to those same items that Trooper Banks testified about.
So what does it come in for? You say, does it come in, does the jury allowed to consider it for its truth?
Well, yes, and the reason...
How?
Well, Your Honor, in the extensive hearings on the motions in limine, first of all, defense counsel was not seeking initially to preclude evidence that... The reason the Commonwealth sought to admit this evidence was to show that we didn't suddenly, mysteriously, magically land upon this individual. We landed upon this individual because when we got a DNA profile from the pipe, the mallet, and the major profile from the black and gray hat, that got uploaded into the state DNA indexing system, which provided a case-to-case hit on a 2002 Medford pharmacy robbery, which was unsolved. From there, the DNA was entered into CODIS, the combined DNA indexing system. And it was only then that we had a person associated with that DNA, and that person was the defendant.
What was the time lag between the crime and the CODIS hit?
Your Honor, the crime occurred in February of 2011. I believe that the processing of the DNA was done, I want to say, in March of 2011. So I think that that initial hit, the CODIS hit, where we learned the identity of the defendant, or that it was a defendant, this is whose DNA it was, that's when we first learned that.
So why can't you simply say, we sent his DNA in to a national database, and we received a response, and as a result of that, we sought a buccal swab? The same way you would, we spoke to a particular victim, you don't put in what the victim said.
Yes.
As a result of that conversation, officer, what did you do?
Well,
You do that all the time.
we do that all the time, Your Honor, but I think that in Commonwealth versus Guy, which was the case where the elderly couple, or at least they had been married for 50 years, were taking a walk in the Walpole Bird Park when the defendant attacked and killed the woman. DNA from that crime was then sent to, I believe, the main lab, which then conducted the DNA testing. And that evidence came in to show why the investigation focused on the defendant. It cannot have been prejudicial to the defendant where the evidence was properly admitted, as Your Honor has just pointed out, through the crime lab witnesses, that actually a buccal swab was taken from the defendant, a DNA profile was extracted from that, and that was compared to those same three items that Trooper Banks had testified about, and there was a match there.
Let me ask you about this police knowledge or what leads to the defendant. Is it different in a case, and the reason I asked about the timeliness, this is a 1-month lag. Would it be different in a case where it was truly a cold case and there was, 10 years had gone by before an unsolved rape case, and the Commonwealth wants to argue we didn't just pluck this guy's name out of a hat? That's how the person was in Missouri. We had to extradite him to Massachusetts. Is that a different case, the cold case versus a case that's a month old?
Well, Your Honor, I think it's maybe sort of more need for the evidence to explain why the investigation focused on the defendant. Here, after going through the victim's cell phones, interviewing the victims, interviewing their friends, there was no connection between this defendant and those individuals. Mr. Vieira testified that he didn't have any clients from Charlestown. They never saw this person before. So where there's simply no connection, it didn't make sense in presenting the theory of the case as to why we suddenly started investigating this person. And it was simply, as Your Honor, Chief Justice Gans has pointed out, it was, and it's this portion of the transcript is set out on page 43 of the Commonwealth's brief, that we never used the term CODIS. We didn't use the term law enforcement.
A national database.
It was
a national database. So
Yes,
you
Your
didn't.
Honor.
I mean,
And
but it was. But the part was the major issue. I know the focus of the objection was on whether or not that would indicate that he was in a national database.
Yes.
That's not my concern. My concern is the admission of the substantive evidence that
That it
there was a
came-
match.
That it was a
As
match.
opposed to we sent something to a national database, we received a response. As a result of that response,
What
we
did you
got a
do?
buccal swab, and we started this procedure. That would have satisfied any question as to why.
That would have, but I would submit that in Your Honor's example, that information, it's whether it's elicited or not really wouldn't make a difference. Where you're asking the jury to draw this conclusion, it doesn't, you're asking the jury to conclude that without the admission of the information, that it was the defendant, because what'd you do next? Oh, we went and talked with this person.
But they do
that's
that all the
inference.
time with regard to avoid hearsay. You know, I spoke to the victim. You don't say the victim told me that Jimmy did it. You let the victim testify to that. You say, as a result of your conversation with the victim, what did you do? Then we interviewed these people. I mean, there's a consistent effort to avoid the eliciting of hearsay without, and still get some chronology in terms of how the investigation played out. That's why I'm concerned about it, because it does corroborate, if the DNA expert had been substantially impeached, which I gather he probably was not here, it would have been essentially independent corroboration for the DNA match, that there was this national database match. I think the word match was used, wasn't it?
I believe the word match was used,
It's
but
not a word that we would otherwise allow, probably, in DNA.
true, Your Honor, but I think that the focus on this national database and the focus on this piece of evidence is really inflated. This was one line of testimony that was elicited from Trooper Banks. It was never mentioned again, I think, except for later. It was mentioned on examination of, I believe it was Leanna Farnham, who was the chemist from the DNA unit, and the prosecutor asked, and did you compare that? Or it was something like, you didn't compare that. This wasn't just something from a national database. No, that was compared to, and she explained what it was compared to. So I would suggest that in the context of this case, the facts that were elicited, where we had these individuals completely separate from Eric Kester in the DNA unit of the State Police Crime Lab, who both did the testing of the buccal swab and tested all of these different items from the scene, obtained the profile, and then testified to the match, and the defendant could cross-examine them, that there was no error in the admission of that testimony.
No error in the admission, or no prejudice arising from its admission?
Well, I would certainly argue that there was no prejudice arising from its admission. I think that where we're talking about the one point is that there was a match, and that was never mentioned again.
But if there was no error in its admission, and if for whatever reason your DNA expert didn't show up, then there's evidence of a DNA match in evidence, which you could then argue to the jury. Are you saying you could have done that?
No, I'm not. In
So
fact,
how is it admissible if you can't?
and we did not do that.
I know you didn't, because you had the DNA expert. But I
Yes.
mean, when you say it's admissible,
Yes, Your Honor.
then it's admissible. And you may be argued as we have evidence of a DNA match of his DNA with the DNA on the mallet, and you could argue that to the jury.
Yes, Your
So
Honor.
you're saying, no, you can't do that, but then you're saying it's admissible, and I'm asking whether whether there's a contradiction there.
Well, as I hear your point, Your Honor, there sounds to be a contradiction there. My point is that it was admissible to show how the investigation focused, not to argue that there was a match in the database.
Did the
which-
judge give an instruction on that point? It's admissible for limited purposes?
Yes, Your Honor. The judge gave a contemporaneous instruction, as defense counsel had requested in the motion in limine, and Justice Haggerty also gave basically the same instruction in the final charge. The instruction said something like, and that again is set out in page 43 of the Commonwealth's brief, people's DNA is contained, or DNA of
But
individuals.
that deals with the CODIS part of it, not the Tassoni confrontation clause issue that Justice Gantz is discussing, correct?
Yes, well, yes, Your Honor.
She didn't say you may not consider it for the fact that it's a match. She just said there's a lot of reasons why somebody may be in a national database.
That is correct, and I think that appropriately focused the jury's attention on,
On that issue,
well,
which is analogous to a mugshot instruction.
Your Honor, if I could turn to the issue regarding Eric Kester. There was no abuse of discretion in Justice Liepensberger's order denying the motion for new trial in this case. As it's apparent to the court, the Commonwealth was not aware of this information. Had we been aware of this information, it certainly would have been provided to the defense in advance of trial. This information regarding Mr. Kester, that he had not passed a bloodstain pattern proficiency test, that he hadn't passed other tests, was completely unrelated to this case. In fact, the State Police Crime Lab conducted a retrospective review of Mr. Kester's work. And
That was what I was asking. Now, where do we have evidence of that?
Your Honor, That information, the retrospective review of Mr. Kester's work, that's contained in the defendant's record appendix at pages 18 and 19. These are memos from Kristen Sullivan that were attached to the Commonwealth's notice of discovery, indicating that it became aware that Mr. Kester had not passed certain competency tests. Those are dated, again, August 15th of 2014 and September 23rd of 2014. And the August 15th of 2014, which is at the supplemental appendix, page 18, says that corrected reports and/or memos are being issued for any case in which inaccurate information was reported. I also submitted an affidavit in support of the Commonwealth's opposition to the defendant's motion for a new trial in this case, where I indicate, and that's at supplemental appendix page 92, after a check with the deputy director of the forensic biology unit of the lab, who checked with the technical leader of the criminalistics unit, who was Eric Kester's supervisor, and there was a confirmation that this case before this court was reviewed, and it was determined that no corrected report needed to be issued. So I would submit that Justice Liebensberger was correct in concluding that this case, or these other nonconformities of Mr. Kester, had no exculpatory relevance to this case, where he responded in February of 2011. The bulk of the nonconformities came afterwards, and the crime lab, if your honors have had a chance to look through the 52 pages of materials in the impounded appendix, show that the administrators at the crime lab, anytime that they became aware of a nonconformity, there were certain steps they had to go through. This is all part of the crime lab's quality assurance system, so they can maintain their certification. And with respect to the one report that counsel's asked you to look at, where there's a contamination event, the resolution of that, or what happened in that event, was apparently that Mr. Kester had touched the outside of the swab container with a bare hand, and then with a gloved hand had also touched it. That was the case where there was a single source profile in a case that ended up being Mr. Kester's. So these issues and other cases, none of this information, it could have been used to, in other words, this is a case that's unlike Murray. In Commonwealth versus Murray, where Justice Hamlin was the trial judge and was the motion judge, and determined that if information regarding the Kendall Street thugs or this Kendall Street gang had been known, then it could have been used to impeach those witnesses who testified that they were just a group of friends. It could have been used to show bias. And most importantly, it could have been used to support the defense that this was really manslaughter based on excessive use of force and self-defense. That's simply not the case here, where none of these nonconformities affected this case. And as Justice Liebensberger concluded, and I think as Your Honor, Chief Justice Gantz has alluded to, Mr. Kester's work in this case was relatively minimal in the sense that he responded to the crime scene with Jennifer Montgomery, who was another civilian analyst from the crime scene response unit, working in conjunction with the troopers from the crime scene services section. They determine, and I think this is in response to your question, Justice Gaziano, they go through the apartment and determine what is evidence in this case. The troopers videotape and photograph the whole apartment before the analysts come in or before any other troopers come in. Then placards are placed down. Those are those numbered placards indicating where evidence might be found. And then the crime scene response unit, the civilian chemists, go through the apartment wearing booties and gloves. And it was Mr. Kester working with Jennifer Montgomery under his supervision, another chemist, and Alana Frederick, who was in training to be a chemist. And they documented and collected pieces of evidence. Mr. Kester's involvement then was, I think it was Ms. Montgomery who even brought that evidence back to the lab at the conclusion of the evening. When Mr. Kester got ready to work on this, he detailed on direct examination exactly what steps he took: photo documentation, butcher paper, 10% bleach solution to clear his workspace. And then what he did in this case was not a bloodstain pattern analysis. It wasn't, there was no single source profile or anything like this that he had anything to do with. He looked for red-brown stains on the pipe, the mallet, the black and gray hat, and another blue Patriots hat that was found at the scene, which no one claimed ownership of, not the defendant and not the victims, and it was Commonwealth's position that this was the hat of the other individual. Mr. Kester took a swab of the red-brown stain, from those items, determined whether it was blood, whether it was human blood, and then those swabs were sent to the DNA unit. And it was the testing by the chemists or the scientists in the DNA unit that confirmed this match between the defendant and those items. The defendant was also seen later that evening by one of his friends who testified that he had a mark on his head. There was evidence introduced of pictures of the defendant's head. In fact, this friend saw this mark and thought it was serious enough that she asked him if he wanted to go into the walk-in clinic for treatment. So I would submit to the court that the DNA evidence, the evidence of the defendant's injury, and also the cell phone evidence, the state police executed a search warrant at the defendant's apartment, obtained some cell phones. From a search of the contacts and the cell phone records, determined that there were two numbers the defendant was regularly in contact with, that of his sister Alice and that of his girlfriend, who was deceased by the time of trial, Megan Brady. That phone only started after the crime occurred in this case. They then did search warrants of the cell phone records for those found a number that they called in common, obtained that cell phone number, got the records for that cell phone, and that cell phone, which was determined to have been used by the defendant on that evening, that cell phone hit off cell phone towers in Charlestown before the crime. At 9:19 before the crime, which occurred around 10:30, it hit off a tower in Arlington, approximately a quarter mile from the West Medford residence where this crime occurred. And later that evening, it hit off a tower in East Boston, where the defendant ended up at this party where the friend asked him about his head. So for all of those reasons, I'd ask that this court affirm the convictions of murder for the murder of John Hatch and the other convictions. If there are no further questions, I'll rest on my brief.
Okay, thank you.
Thank you, Your Honor.
All right.